Good morning, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Wanted to come in and talk to you today about privileges and immunities and the freedom of movement. So what we're going to do is we're going to look over LII-WEX and their definition of arrest first. And as we see, this is arrest. An arrest is the use of legal authority to, and it says specifically here, deprive a person of their freedom of movement. So before we go any further, let's look at legal authority. And you notice it's got blue highline underlight under legal. And then there's a blank space here for authority. So it's actually two different words that are going to be defined here. So let's look legal. Legal means anything having to do with the law. Legal means anything having to do with the law. However, in everyday conversation, we often use legal to refer to something that conforms to the law, or at the very least, does not break it. We often use legal to refer to something that conforms to the law, or at the very least does not break the law. Historically, the term was used in contrast to equitable. In that time, people could take their complaints to either courts of law or courts of equity. Both systems gave people different remedies to their problems in the form of either legal relief or equitable relief, respectively. Typically, legal relief awards the wronged person money damages in order to make them whole. The aim of legal relief is to put victims back in the positions they were in before the wrong occurred. Remember, folks, this is why I tell you to pay attention when they send you to court, and the first one that they have you go to an initial appearance is called a disposition hearing. They're going to disposition you. That is a victim. And opposite of arrest, making you stop, to make you do something is the same equivalent of a crime. To prevent somebody from doing something that they were doing in law, or to make them do something that they're not required to in law, is the same thing. It's making a victim. It's violating your freedom of movement. Today in the United States, most courts have merged the two systems and can provide either type of relief. Legal is also used in many terms of art being grammar. Legal is also used in many terms of art within the law field, like legal action. See also legal cause, legal duty, and legal fiction. This one right here is the one we're going to look at first. Legal fiction is an assumption and acceptance of something as fact by a court. Legal fiction is an assumption and acceptance of something as fact by a court. although it may not be true, to allow a rule to operate or be applied in a manner that differs from its original purpose, while leaving the letter of the law unchanged. The letter of the law is one thing, and then somebody will bring in a presentment of facts according to or related to the law, although it may not be true. And this is to allow a rule to operate or be applied in a manner that it differs from its original purpose. So if you're not going to go by the original purpose, then you're in violation of the law, because the law has two establishments. Like we see here, it says the letter of the law and the intent of the law, which is the purpose. And that has to go to its original intent, purpose. So let's go back. Now let's take a look at legal action. Legal action is a phrase that primarily refers to the act of bringing a lawsuit, prosecution, or judicial proceeding to obtain some sort of legal remedy or to ascertain or protect a legal right. In the Fisher Controls Intern Inc. versus Marin case, for example, the Supreme Court of Iowa defined legal action as a formal proceeding in any forum in which a party is entitled to seek the relief being asked under authority of the state, including bringing a claim before an administrative agency, rendering it substantially broader than an action. Legal action may also be used more broadly, legal action may also be used more broadly, should be more broadly to refer to any action taken before the law. So what they're doing is they're making a presentment of assumed facts, or presenting facts that are then assumed in a legal fiction capacity before the intent of the law, before the letter of the law. They're bringing that first. They're bringing the legal fiction first. And that's like I've said before, the legal fiction, if you're going to be involved in these administrative courts, that legal fiction has to be a corporate entity. You cannot hire an attorney in these courts to file a lawsuit or anything unless you're a corporate entity for that administration process. Now, if you're talking about a court of, what they say here, where was it? They had, oh, there it is. To either courts of law or courts of equity, lawsuits, prosecution, or judicial proceeding. Now, the lawsuits or prosecution, notice there's a comma before or after each one or both of these, and then it says or. So the judicial proceeding is different than courts of law, wherein you present lawsuits or prosecution. Judicial proceeding is the equity, okay? So you still have the courts of law or court of equity. Your equity can only be a judicial proceeding. in these courts of law, it's a lawsuit or prosecution. So you have to go to the judicial office for the equitable relief. And again, this is the Judicial Officer Department. Let me see here, pull it up so you can see it one more time. Judicial officer is who you make your equitable relief from to make all parties whole. And this is the Judicial Officer Department is a neutral, independent forum within the United States Postal Service, comprised of the Judicial Officer, the Office of Administrative Law Judges, and the Postal Service Board of Contract Appeals. And this again relates to those corporate entities. This is the Judicial Officer Department that you need to address, in my opinion, as it relates to equity, because you don't have the capacity to hire an attorney to present a lawsuit or a prosecution. Those are corporate activities. Okay? So let's go back. Legal means anything to have to do with the law. The law refers to a system of rules. The law refers to a system of rules that regulate the conduct of a community and is often enforced by a controlling authority through penalties. When people refer to the law of the United States, they most likely mean its law system. The U.S. employs a common law system, which means the laws are typically derived from judicial decisions instead of statutes. Okay? This is how you break the corporate veil of the statutes, codes, and rules and regulations, is that they are federal acquisition regulations that are required to have contract terms and conditions required to implement statutes, executive orders. We'll show you that one here real quick. 48 CFR 52.212-5, and that says it is the title. 48 CFR 52.212-5, and it says specifically contract terms and conditions required to implement statutes or executive orders concerning commercial products and commercial services. So whenever they're having a fine along with that statute, that is telling you they are trying to enforce a contract, and that is the judicial element. That one judicial element is all it takes to remove it from that state court. It is the proof that they're trying to operate a corporate law against a common man that doesn't have a corporate payment. They're not organized under the laws of the United States through the Federal Reserve as a corporate entity. If that is not there, you cannot contract terms and conditions for commercial products and commercial services as part of the judicial system. Again, you have to be a resident or a United States citizen. Law of the United States. It's not the United States of America, folks. It says the law of the United States. And they most likely mean, they're telling you here what it actually means. Law system. A legal system is the framework of rules, procedures, and institutions that a community uses to interpret and enforce their laws. Okay? So it's merely an interpretation of the law, which here the law is stating it's the United States. So it's not United States of America, and therefore it still remains corporate. Okay? However, in everyday conversations, we often use legal to refer to something that conforms to the law or at the very least does not break it. When they are pulling you over alongside the road, if you have a card, well, let's look at the actual definition of credit card. Credit card is any card, plate, or device used to obtain property, money, labor, or services on credit. So when you're traveling down the road and they see that nice little plate on the back of your car and they decide they want to produce some commerce and get some kind of mark on their quotas so they can reach their quotas, then they're going to feel free to just go ahead and pull you over. And that itself is a violation of law as it relates to the common law. And that is your constitutional access, because again, they're attacking a person that they have no right to even have knowledge of. But again, I'm going to tell you that they do this because you're advertising. That plate is an advertisement. That credit card, the license, it's a card, and they use that to obtain money, property, labor, or services on credit because you transferred that card, that license, that's property of the state, and you're acting as a transfer agent in transferring property when you hand it over to the nice policy officer so he can take it back to his car and take the information, enter it into the system, and conduct his business on your credit. Okay? So they started out by initiating the obtaining of money, property, labor, or services by you transferring a card that is going to allow things on credit. Yet when you go to court, they tell you have to pay fines, fees, and penalties. If you understand that everything is on credit, then fine, take it from the credit account. That's what you're trying to access, and that's what they actually access. As I've showed you before, they enter you in as a firm. They don't enter you in the last name. They enter in a firm name, which is only the first four letters of the last name, and they're using you as a broker, the one that's making the transfers, because that's what you acted like when the nice policy officer pulled you over. Okay? So let's look at the next one. Authority. Authority is the official permission or right to act, often on behalf of another. Authority may also be a person or institution that has power over another person. Authority as agency is the power to act on behalf of another. The power delegated by principle to an agent. So anytime you're dealing with any of these agencies, programs, departments, and they're all considered, well, they call them employees, but another term for employees is agent. Why? Because they're working within an agency of some sort, which means they have a principal and an agent. Authority is central to the law of agency. If someone takes an action on behalf of another without authority to do so, the action is usually void. Actions carried out beyond or outside the scope of one's authority are ultra vires, beyond the powers. So when the nice policy officer asks for that ID and you hand it over to him, that is ultra vires. That is beyond the powers. Okay? Doesn't matter what kind of authority that officer thinks. His principal is the chief of police, the county sheriff, the mayor, whatever, and he is acting as an agent. Okay? He is acting on behalf of the principal. Therefore, he is liable as principal for going beyond the powers of his principal. The mayor can't travel down the road and pull you over because of that plate and use your credit. The county commissioner can't do that. But somehow these policy enforcers that have those people, mayors and county commissioners and state governors and all that, they have all these people as principals, yet the police as agents think they have that power. They don't. If the governor doesn't have the power to pull you over alongside the road to access your credit, then what makes you think that these people do? They don't. In the context of agency, authority may either be actual or implied, apparent, constructive. It is never actual unless you authorize it yourself. Until then, it is implied, apparent, or constructive, and that authority is most often constructive as a constructive contract or a constructive trust. Now, the thing about constructive trust is it merely takes the transfer of property. And like I said, if you're going to transfer that license over to the officer, what you've done and he has done has just committed an act that constructed a trust, not a mere contract to access the credit, but a trust. You transferred state property over to a municipal employee, acting as if though you were an agent that was allowed to do so because you had that card in your possession by authorization. So now you see you both are taking under a principal agency and acting as agents. So it's agent to agent. You have to get over this stuff and quit doing these stupid things. Actual authority is expressly or explicitly delegated by a principal to an agent. So when the officer is over there on the long side of the road and he says he has authority over you, when obviously you were given authority by the State Department of Transportation to hold that license, and he was given authority by a local municipal mayor or a county commissioner through a sheriff, then he too is an agent. He is not a principal. He cannot have authority over anybody. He is authorized himself, just like you are authorized. That puts you both in the same capacity as authorized agents, authorized representatives, whatever you want to call. But one does not have authority over the other, and that is an implication, and he is trying to construct a contract to get himself a paycheck with that quota. Okay? So implied authority, on the other hand, is not expressly delegated. Instead, it is circumstantially inferred that the principal is meant to confer this authority upon the agent. So this is what the officer's doing, is he's saying that as an agent of the chief of police, the chief of police has circumstantially inferred that he, as principal, has the authority to assign an agent that can act as principal. Again, if you're an agent acting as principal, you're liable as a principal. Okay? So if you're out there saying that you have authority over somebody else, that's the acting of as a principal. If you're the guy in the car that says, no, you don't have authority over me, that is not acting as a principal by assignment of agent. That is acting as self, negating any lawful authority being constructed, implied, or otherwise. Okay, the last one we're talking about here is the freedom of movement, folks. Freedom of movement. When we click on this, watch what it says. Ready? 1, 2, 3. Privileges and Immunities Clause. So when they stop you alongside the road and prevent you from freely moving, it is the automatic relation to the Privileges and Immunities Clause. The Privileges and Immunities Clause of Article 4, Section 2 of the Constitution states, the citizens of each state shall be entitled to all privileges and immunities of citizens in several states. This clause protects fundamental rights of individual citizens and restrains states' efforts to discriminate against out-of-state citizens. However, the Privileges and Immunities Clause extends not to all commercial activity, but only to fundamental rights. So when they pull you over alongside that road and they're trying to provide commercial activity, they're already violating your fundamental rights and trying to incorporate a legal construction of a contract. There has been a great deal of scholarly debate over the purpose of this constitutional provision. One source of insight as to the purpose of the Privileges and Immunities Clause is its textual predecessor. This is why we do etymology and we go back to the origins. Article 4 of the Articles of Confederation, which stated that to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants, let me read that one more time. It's not resident, it's not a dweller, it's not an occupant, it's not a tenant, anything like that, but free inhabitants of each of these states shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall be free ingress and regress to and from any other state. This is Psalms 121, verse 8, wherein the Lord shall preserve thy going out and thy coming in from this time forth and even forevermore, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as the inhabitants thereof. The Federalist Papers also provide some insight into the clause. Madison's Federalist number 42, Madison stated, those who come under the denomination of free inhabitants of a state, although not citizens of such state, are entitled in every other state to all privileges of free citizens of the latter. That is, to greater privileges than they may be entitled to in their own state. This is the Ninth Amendment, speaking about the limitations of the rights in the Constitution are not enumerated. We have rights that may or may not be enumerated. That means the ones that are enumerated through that Constitution, that's not granting us those rights. Those are just the rights that have been recognized and enumerated, and there may be others that are not mentioned. In Federalist number 80, Hamilton expressed his belief in the clause's importance when he wrote that the Privileges and Immunities Clause, the version in the Constitution, is the basis of the Union. It's the basis of the Union. Because of the ambiguity of the clause, much debate surrounds the particular rights which the Privileges and Immunities Clause protects. I don't say that the Privileges and Immunities Clause protects anything. Again, it's just stating what there is, and you have to protect it. You have to protect your privileges and immunities. You have to stand up and take responsibility. Ain't no one else out there going to do it for you. It's been proven time and time again. and this is getting ridiculous. If you think that you need help and you're looking for a save-a-hoe, that's what you're going to get, because you're nothing but a lazy hoe that won't do it yourself. Get off your ass and fucking start doing things. This is simple reading. Some scholars believe that it protects the traditional common law rights conferred by particular states to their citizens. The majority opinion in Corfield versus Coryell, however, gives a different approach, stating that the clause protected only certain fundamental rights. The Privileges and Immunities Clause, as it relates to freedom of movement, is the most fundamental right there is. And that includes moving your mouth. So that is freedom of speech. That includes moving your hands. So that includes the freedom of speech and the freedom to express yourself in writing, to make it known. What is written is as it is written, so shall it be. So make sure you know how to coin your words or purse your lips. Protection by the government will never happen. Again, I'm telling you, you have to protect yourself, and the only way you can protect that is through the knowledge. That is the true benefit. My people are destroyed. My people are perished for lack of knowledge. The enjoyment of life and liberty with the right to acquire and possess property of every kind. So you can acquire an automobile or a motor vehicle, your choice. You just have to know the difference and how to clarify it and express your use of it, and to pursue and obtain happiness and safety. Every one of their laws is for safety reasons, yet they're not protecting you, they're protecting the government. Protection by the government, for the government, of the government. It's a little bit different than the Declaration of Independence, isn't it? Subject, nevertheless, to such restraints as the government may justify or justly prescribe for the general good of the whole. Now, this is where they take a body of people and call it the whole, where one person can be retained, detained, obtained, arrested, and mutilated and murdered, and it doesn't matter. They don't see the individual as a whole within themselves. They're seeing the whole as a society, the community, and every last one of you is part of the whole. And if one of them is a resident, then all of you are a resident. That is the assumption of the facts presented to the court. You are placating that you are a resident by having that very ID, that card, to have to obtain money, property, labor, or services on credit. If you don't have that, then they can't get it. Okay? The majority opinion enumerates a few specific rights, such as the right to live in and travel through states, the right to sue in courts, etc., but also notes that it is not a comprehensive list. It is not all of the rights. Like I said, the Ninth Amendment tells us that there are certain rights that are not enumerated that they have to be careful of. Corfield became increasingly prominent in later years, particularly in the context of issues like slavery and universal suffrage. Because when they stop you alongside of the road and tell you you can or cannot do this or that, you can or cannot do this or that, they have violated every right you have and made you a slave in that very instance. As soon as they pulled you over, they're trying to enslave you to a corporate entity, and that is why they ask you for that corporate ID, and that is why they present you in court and say you have to have an attorney because you presented a corporate ID saying that you're a corporation, when in fact you're not. Okay? I hope you guys enjoyed the stream today, the information put out, the content and everything. And remember, folks, I love you. I don't give a rat's ass whether you love me back. So may God bless you and have a good day.